We start the third session, start the third part, so we now have more free spaces, but at the same time, we have also some new people coming. I think we'll fill this room in, and before lunch, we had three most popular words: PPP, private public partnership, non pricing criteria, and the lunch, of course, was a very important word before the lunch itself. Okay, it will be interesting to understand after this panel, like which popular words we'll have now. But this is going to be very dynamic because the control and procurement, we can talk forever about that, and so many nuances are there. The whole spectrum of various control formats is here, is introduced to this panel. I'm so happy that we have such a representative panel. Highly representative. We have the head of the accounting chamber, Ms. Olha Pishchanska, is with us. She's in Brussels now, so it's very, very. It's actually aligning with our exercise, on public procurement. Oleksiy Aleksandrov, State Audit Service of Ukraine. Olga Nechytaylo will be with us online. Inguna Sudraba, my colleague, my project colleague, who is a team leader on fifth component. And we also have with us Denis Selin, head of public control NGO. And we also expect to have Maxim Nefedov with us. He will join us later. But we have very tense agenda now. Yeah, I'd like to pass the floor to Ms. Olha and express gratitude. Ms. Olha, thank you for your, despite that you have as tense agenda as we do, you have the mission Brussels, but you're still with us. Please, Olha, we'll be grateful for your speech. Okay, so good afternoon. Thank you so much for this opportunity to give my speech. Dear ladies and gentlemen, greetings. So public procurement is itself an indicator for us to see if the public management and administration, how effective these are, because all components are here: strategic vision, planning, managing finances, and also the executive discipline in general. Via the procurement, the state is implementing its policies, all of these, providing everything to defense sector, schools, hospitals, restoring infrastructure. If these processes are effective, competitive, and transparent, it means that there is sustainable and strong state, that it's evolving. During the war, the full-scale war, when our own resources are limited, and there is a huge number of critical needs, transparency, timeliness, and results of procurement, it affects directly our social stability and our defense sector capacity. So we have to minimize the risks in public procurement sector, and first of all, via the systems of effective control. And the accounting chamber, as the highest body of external state audit, it has a broad mandate. So we ensure independent and professional external audit, fully compliant with international standards. And today I can tell you about the results of 2024. In 2024, we had a series of audits. Upon the results of these, we identified violations in public procurement. 500,000 hryvnias, that was the amount of violations. So billions of hryvnias, millions of hryvnias, yes. And substantial violations and deficiencies, we identified these in such important sectors as defense, healthcare, and infrastructure recovery. And it means that the PP system in Ukraine requires further improvement. So from our side, I just want to note that one of the important steps on this way is on January 1st, 2025, the amendments to the accounting chamber law came into effect. And in this updated law, the parliamentary control and oversight strengthened. Now the chamber, during the annual reporting, has a right to initiate meetings in Verkhovna Rada to make certain decisions if recommendations of the chamber are not implemented. We have to regularly monitor and analyze the chamber's decisions implementation. All legislative changes and amendments, these create a strong mechanism. As of now, for the parliamentary support and to implement the recommendations of our chamber, and we are pretty sure, we're confident then that in future, This will affect the speed and quality of the Chamber's recommendations implementation. It's important when we talk about the PP sector to draw attention to the Ministry of Economy report. And it contains the analysis of the procurement statistics and generalized data on the control. The accounting chamber regularly is performing preliminary analysis of the report and provides an assessment of all the information that's in it. It identifies problems and designs recommendations. By the way, in 2024, we adopted the procedure of the analysis to make sure that we use the same criteria annually and for us to collect some historic data, and to have this retrospective analysis and check what is the dynamics. I just want to stress that one of the key concerns, in our opinion, in our conclusions for 2023 is that mass procurement without competitive procedures, what we've seen. 92% of procurement carried out beyond the electronic procurement system, and requesters only published some of the reports, not all of them. We understand the key reason of that situation is that item 13. Because of the item 13 with the list of exceptions when agreements are concluded without open bidding. At the same time, I want to say that mass implementation of this procedure entails a lot of risks for transparent and competitiveness of procurement. Therefore, after analysis, accounting chamber provided 5 recommendations. 4 of recommendations already are implemented. And we also define at the strategic level the goals of the state policy in public procurement sector. With Ministry of Economy, we actually negotiate the amendments on how to inspect the situation to check if there are the open biddings, electronic catalogs used.
And also the recommendations for the preparation of the annual report, which must be, again, its component. And another thing that's important for us is the reports on the functioning of the procurement system are published on the website and are available for the whole of society. Unfortunately, still the recommendation concerning the review and the narrowing of the list of reasons for the non-competitive procurement remains open, and after the specification of the respective changes under the draft law 11/520, again it will be taken into account what we did the previous year when.
These were mostly with limited access. Measures with limited access, confidential, but we can give some information. For example, the audit for the Ministry of Defense in procurement compliance on designing and modernizing the weapons and ammunition. So what we did, we identified certain facts of ineffective management of budget resources with total amount 156 billion hryvnias. Also, the audit of compliance for the defense procurement of UAVs by Special Communication Service of Ukraine. So this report contains confidential materials. At the same time, I want to tell you that we identified the inflated price of procurement, totaling over 3 billion hryvnias. Positive things. So all these problems were corrected during the audit. We also found identified some violation of the legislation, more than 3 billion. This is the amount of the violations. And the budget losses due to unjustified managerial decisions to be made, almost 200 million hryvnias. So we can actually understand that the money could be used for the defense purposes in a better way. In 2024, we also have the audit to understand if everything's okay with the procurement of the UAVs and means of monitoring of the state border. So we found again some ineffective management of budget money because 315 million hryvnias were not used in timely manner. We identified that all the procurement announced within the period for the administration of the State Border Service, now the UAVs and monitoring systems for the state border. So there was no bidding. Basically, there was no auction. What was the reason? Because the responsibility was transferred for the project, and it actually affected the quality, of the bidding documents. And we had some interesting audit for the Ministry of Health. Procurement of expensive equipment to improve the quality of medical assistance and diagnostics for people. So we identified that in 2023, for the first time, MOH procured equipment for healthcare facilities in a centralized manner, which ensured the higher effectiveness, and they managed to decrease the cost of procurement in that way. But at the same time, despite the large mass of procurement, they managed to save the money. But still, MOH couldn't commission the equipment, according to the plan because of some technical and organizational reasons. And it actually itself is a proof that we have to take into account not only the economic factors, but also many technical aspects to make sure that this procurement takes place in future and for the money not to be frozen at the accounts, when this equipment is necessary, when people actually require this. Of course, if legislative violations during the procurement. So our chamber studied that in 2024 in the process of other audits. For example, civil defense in municipal enterprises, also in schools and educational establishments, 230 million hryvnias, that's the amount of violations. And there was an issue of they detoured the open bidding and unfair competition. So the key reasons of these violations and flaws is, of course, the incompliance of contractors' qualification of experience. Contractors replaced some materials without special inspection. So the services which were not provided were actually paid for, and other problems as well. And in general, what I can tell you that every audit that is carried out by the accounting chamber, some part of it covers the public procurement sector. And almost in each audit, we have remarks, and on the procedure itself, the procedural errors, or they inflate the price, or they fail to comply with the contractual obligations, or maybe the penalties are not established when there are certain violations. So just to draw the line, I want to tell you that in the public procurement sector, this sector is, of course, one of the very important sectors, one of the most important. So the level of integrity and transparency affects the implementation of state policies, especially now. The results of audits for 2024 show us that there are some positive changes in procurement, and also certain social problems are still there, like ineffective management, ineffective planning of procurement, especially at the level of communities. Therefore, we need to enhance institutions. For example, we need to enhance the potential of chamber, and therefore we will have better audits, and our recommendations will be taken more seriously. Of course, it requires innovative approaches, high level of auditors' qualification, and interinstitutional interaction. And the accounting chamber cooperates with the project. In this matter, we have the support from partners, the EU for PFM team, and we have some joint steps taken. So we've already generated procurement recommendations, trainings for more than 150 auditors. We have regular studies of, we study the best practices, best audit practices of EU countries. We're grateful to our partners, and we do hope that we will continue this cooperation. And in general, when it comes to public procurement, first of all, there's still a possibility to improve this. But we can see also how much the country is losing. Well, thanks to the audit, ineffective public procurement management entails huge losses. So I really want us all to have great and productive day. Thank you, dear partners, for your support, and thank you so much, dear participants. Thank you for being actively engaged. Thank you. Thank you, Ms. Olha. Thank you so much. I do hope that colleagues from Accounting Chamber will stay with us because we'll have questions, of course. The key word of the third session, billion. I guess, yeah. So we'll talk about billions in various aspects when it comes to control. And I would like to pass the floor to Oleksiy Aleksandrov, who actually leads the Department of Monitoring and Checks of Public Procurement. So this is basically, he's at the front line of the State Audit Service when it comes to these functions that I mentioned. Okay. Please. I'd like to have the presentation on the screen now, and yeah. Dear colleagues, good afternoon. My name is Oleksiy Aleksandrov, head of the Department of Monitoring Checks of Public Procurement State Audit Service. On behalf of the service, I'd like to say a couple of words. Well, first of all, thank you to Aleksandr Shatkovskyi. Eric Smizalis, thank you so much. You regularly engage State Audit Service to all the events and to all the activities. Thank you for the support, project support. Thank you for your feedback. And State Audit Service hopes that we'll have this productive cooperation in future under the component and under the PP component. And we, as the controlling bodies, the PP controlling bodies, we are regularly engaged to all the discussions as a body that, well, up to 90% in our activity, up to 90% of our efforts is about inspecting and preventive measures in the procurement sector. So that's what we do mainly. So legislation that regulates our activity gives us 4 ways to control the compliance in procurement sector. So we have basically 4 ways: monitoring for procurement, inspections, state financial audit, and examination. So these financial control measures, these are different. These are different blocks. There is a certain goal for each. And the methodology for these state financial control measures is like a little bit different. If you talk about monitoring of procurement with the quantitative indicator, okay, this is like the largest block of our activities. Prevention is the most important one, and we need to prevent the inappropriate use of requesters' money. So, for example, if we talk about state financial audit, it's a different philosophy. First of all, here we achieve the goals of procurement. We identify the risks, the problems that require solution, and specific recommendations are provided on how what requester should do in a specific situation, and how to prevent the systemic violations in the PP sector. If we talk about inspections and examinations, so in this block we speak about paper inspection and the procurement process per se. So the availability of items, taxation, accounting, so the contractual obligations, everything. monitoring of the procurement procedure identified under the law, under the PP law. So the compliance of the requester. So we basically check if the requester complies with the applicable legislation.
And so in the monitoring of procurements, we see that monitoring is in no way a panacea, a one-size-fits-all solution, but it's flexible. It is in compliance with today's requirements to achieve today's goals and to avoid financial losses. Monitoring is carried out not over all the procurements, but during the martial law, we can monitor only open procurements and simplified procurements, I mean direct agreements that are concluded in accordance with the provision 13. And as for the statistics, you can see that we carried out monitorings, and we found out violations in 90 cases, and then we found violations in over 89 million hryvnias, and we managed to resolve this situation via cancelling some of the contracts. And this situation shows that in public procurement we face challenges for both the client and the oversight body, because this number from year to year has been steadily growing. Not by leaps and bounds, but it's growing, and we have serious miscalculations on the part of some of our clients. And we also see that this sum shows that based on the results of the state audits, the majority of the participants adequately perceives our conclusions and responds to the recommendations that are provided during monitorings of public procurement. And it should be noted that for several years, 3 to 4 years, the complaints to courts account only for 8 to 9%, and we already observe a certain trend. And 90% of monitoring cases result in a balance in the field of compliance. In public procurement, the auditing service carried out 400 checks, 185 billion hryvnias. And there are violations, of course, that and there is money that cannot be returned to cannot be returned to the government, 1.72 billion hryvnias. So we see that 203 million hryvnias was reimbursed to, and now we are looking for the assets, and we are urging the client and the law enforcement bodies to use the appropriate measures. If you're interested in this statistics for 2024, you can scan this QR code on the screen. This is the public report of the head of the auditing service. So it covers all the areas. It provides analytics and numbers. So you can even leave some comments there. As for the positive aspects in 2024, it should be noted that the achievement of the State Auditing Service, together with the Ministry of Economy and with the help of the World Bank and the developers of Prozoro, the State Auditing Service finally got back to risk indicators as the legally defined basis for the monitoring. We finally have the respective order of the Ministry of Finance that came into force on November 9, 2024, and we continued the selection procedure based on the risk-oriented approach. It should be noted that even taking into account the fact that we had only 2 months in 2024 to work on the risk indicators, then we still see that in December 2024, we have 402 procurements based on these indicators, and which accounts for 24% of the total number. And the program document concerning the support also requires effort on our part, and we confirm that we will do our part. And this we have 20% from the general number of the procedures must be selected based on the results of the risk indicators flagging these procedures. And even taking into account the current state, we even exceed this quota. However, it should be noted that risk indicators must be flexible because, first of all, our legislation is flexible, and we understand that under martial law, it may be amended several times. It is being amended all the time, and we see the changes in approaches to our procurement activities, and we of course have the ongoing digitalization and electronic system of procurement, and risk indicators directly depend on the improvement of the electronic system of procurement, because it's the only source with the help of which we receive information and build our algorithms for when the indicators flag certain processes. And the faster we have this electronic procedure, the more opportunities the state auditors will have to see some risk operations. What we have as of now, what are our prospects, and what we face today. So the State Auditing Service, together with the Ministry of Finance, is the auditing body, and based on the framework agreement, Ukraine facility, this is the fundamental agreement that for the most part, in my opinion, looks as an invitation of the European Union to Ukraine to join this union. Why do I think so? Because Ukraine should be able to show that the money allocated within the framework of this agreement are used transparently and effectively, and they are controlled by the government. And so the order should be done in the way that the auditors, the observers could say that the money is used effectively to achieve certain results for which they were provided. And of course, this is a substantial challenge for the participants of the process, for the national coordinator, for the Ministry of Finance, for the State Auditing Service. And the Auditing Service has been focusing a lot of attention this year to make sure that it has the one legislative position in terms of the procurement done within Ukraine facility. And in fact, this tool is in no way creating any new measures of control, of state control. The state control remains the same, just as I've already outlined it for you. And the clear focus of the State Auditing Service is on the focused on the coverage of this funding, and the auditing service is now looking at the funds allocated in the second half of 2024, the money allocated to education and healthcare. Now we also see the money going to the field of where we protect our veterans. And again, all these fields must be covered by the state financial control. But just as with any other measure of financial control, we face risks and precautions, and there are issues that must be raised and must be discussed with the stakeholders and all interested parties in this process, because the earlier we define the ways, the solutions, the more effective we will go through the external control and audit of the whole process for the implementation of this plan for Ukraine. And the major factor for the violations of the conditions of the agreement, right in front of you, we have the cases that were documented during the state financial control, during monitoring, during procurement. They exist, and we show it to you to make sure that we can together look at the proposals of all interested parties and to show customers that there is such a tool and that we must fulfill the conditions of the framework agreement, and that we are ready to help at all levels so that the customers don't see this service as a punitive measure. And the whole philosophy of Ukrainian facility is focused on a specific on achievement of specific results, and achieving these results is a clear indicator of fulfilling this program and commitments, and nobody sets the requirements to find specific violations or large or outstanding cases of abuse. So the task is to understand the algorithm, to understand how the system works, and how it works in order to use this tool. And that's why with the measures of financial control, when we had the allocations into the 2024, we were very understanding towards the customers when it came to issues that cannot be resolved. But we suggest to carry out some measures to, first of all, protect their own interests, to protect the interests of Ukraine, because in case of systemic violations, budget allocations will be stopped. So what factors among those that we should talk about? So this is the lack of information among customers as to how the money is spent. But now we already work with those who receive this money, and now we already have these allocations in the process. And there are precautions outlined in the framework agreement, and we see that in 2025 it's easier for us to control it. But in 2024 we had a communication issue with the customers and and those who administered the money, so either via subventions or dotations. So what they should do and what indicators they should have. So customers in the regions mostly did not understand what they bought and did not understand what the requirements to the goods are. And so first of all, this is the lack of awareness among customers of the conditions of specific documentation and concerning the criteria of, for the those who who provide their goods and services, and then what to do. They are not quite aware of, they were at the time not quite aware of what to do with the documentation, how to go about it, but now we have productive dialogue. We express our concerns, and as a practicing body of financial control, and as the body that is responsible for the policies, of course, we have our own vision, and we must ensure this preventive control. But this issue is being resolved, and I'm sure that we will do it successfully and do this in 2025. The low level of control of internal control of the money, again, this is in Appendix 7 of the framework agreement. So we see that in the internal control of the customer doesn't work. There may be some objective reasons for it. It is not for us to talk about that, but the internal control must be in place. And there are program documents and directives of the EU, and it should be reflected in the framework. It also is reflected in the framework agreement, because the customer has a range of issues that they must focus on before they sign the contract. What concerns the supplier, the acceptability of goods, all these questions must be resolved in a preventive way by the customer at the stage of planning of its procurement activities, or at the stage of the qualification of participants or winners of the tender. So this is a lack of awareness among the customers that there is such a range of conditions, and that the procedure continues even after the conclusion of the contract, and the documents are stored for up to 5 years. And again, there could be some checks targeted at the customer or at us, where there will be audits carried out concerning the money that is allocated for public procurement. A lot of customers do not understand how these processes should go, and we have a lot of customers, and we must and they must also take care of the internal control. A lot of questions that they receive during the state financial control arise, but if they had those internal control measures, then those questions would never be there in the first place. There are customers who, for example, we're talking about territorial communities. So the territorial communities that went auditing, the ones that start to look at the core of the issue, and 8 out of 10 issues could be removed with the help of internal control. That's why, again, we must focus on the internal control measures, but we see these risks, and we think that this is a real risk during the implementation of Ukraine facility. As for the lack of information on the samples of emblems, there was an issue in 2025 when everybody agreed that we must have these emblems in place, and this information coming from the government states that these are the targeted allocations, and this information on the emblem must be present in this documentation. This is the regular practice in the European Union. If you travel across the EU, you see that a lot of infrastructure objects have such emblems, and this is a standard practice, but we must fulfill this requirement, and the service must check it.
So, the ways to improve and how to optimize the control over PP from the audit service. Well, this is our plan for the short-term plan, that is, because as I told you, the Ukraine facility plan by 2027 is functional, and I do hope that we will finalize it and we'll maybe get some other donors, flows, financial flows in our economy, because we need that. In State Audit Service, of course, is not beyond the process. We are in it, we're engaged, and we need to unite to optimize the activity, and we can see the potential. There is definitely potential. We do have it to run certain changes and legislative changes to push these for us, first of all, in our activity to optimize our results and to enhance our institutional capacity. Thirdly, to show that state financial control, public financial control in our service is effective. It's not about numbers. It's not about quantity. It's about algorithms and standards primarily, which are offered by the audit service now. And for us to achieve the highest results, the high standards, comply with these, we see those challenges. These are the challenges that actually I show you on the slide: harmonizing and aligning the standards of procurement control with EU acquis, relevant to acquis. So what do we mean when we say that? So we have to achieve these goals. Legislative initiatives on monitoring of procurement algorithm to be introduced in specific laws and bylaws. We have certain results already on how to enhance institutional capacity of monitoring, thanks to amending the law on key principles of public financial control. Also, we have certain proposals for the mechanism to suspend procurement during the monitoring period. We are discussing right now it with all the stakeholders, all the bodies, because there are some opinions that monitoring has to be purely preventive, but there are some objective and subjective grounds, to suspend that. Some people say yes, some people say no. Some are against, some are for, but we have the understanding of the problem and we try to move forward. So we will. Also, within this indicator, we know that there must be changed approach to administrative responsibility in procurement. So we need to minimize the responsibility for those minor violations which do not impact the results of procurement. For example, errors in bidding documents, or if something is not published, something which in any way doesn't affect the results, but to strengthen the responsibility for some major violations that impact the procurement results. We have two goals here that we set: protecting those requesters who face some injustice, because we understand that any participant is investing some money, contributing something to run this activity. To take part in bidding, one is investing some money, and there are always some expenses. And what we face, that sometimes the requester is doing this, that for participants it doesn't make sense even to take part in the procedure, because one understands that one will just fail. So we need to strengthen the liability for major violations, and it seems to us that this will stimulate the requester to comply with the PP law. And on the other hand, if we establish higher penalties, this will somehow stimulate the requester to protect the interests of those participants who were declined without grounds, or who weren't declined if they had to be declined or due to other reasons. And this will somehow stimulate the obedience with the law. We also have an initiative to establish liability for failure to comply with the state audit requirements during the monitoring of public procurement. So what do we mean by saying this? As I told you, some monitorings fall under appeal. But this, so even if we prove the auditor's legitimate actions, these contracts or procedures, these still are not canceled and nothing happens. So it cannot continue like that. We need to have, there must be certain liability. And I think it should be not just for the authorized person. The authorized person has done the job, and then the process of contract enforcement, it's not the authorized person who's doing this. So basically, this is the root cause. So certain auditors' focus should be on officials or requesters, managers who fail or avoid complying with those recommendations or requirements of audit service. So if in the court it was proved that certain limitations are legitimate regarding this requester, that's something we work with as well today, and we want the civic society and NGOs to support us with that, or to provide some recommendations, because the only way to stimulate the requester to stick to the law in our legal system and our mentality is to increase the penalties and fines if one fails to comply with the law. So, we also have the institutional capacity development for the State Audit Service, and we are updating the classification of violations, systematizing these based on the Supreme Court decisions. For each auditor, if the Supreme Court gives an opinion on a certain clause, for our auditors to understand what opinion should be given, what to conclude. And we process these recommendations and amendments, and improving internal mechanisms of procurement control. So primarily generalizing the court practices, enforcement practices, and making sure that every auditor knows what to do in each regions and everyone knows what is the algorithm. And the very last thing is to updated system of control, procurement control, with integrated international experience. Also professional development and improved communication. What we would like to get, digitize the system as much as it's possible. Public financial control over procurement, it should be digitized. We already have some ideas. We know that state financial control, it's still of that, Soviet type. It's very hard to transform it, but we have good examples in monitoring of procurement, and Prozoro works wonderfully. So yeah, we have some great cases, success stories. We want to digitize, right? At least in 2 out of 4 of these blocks to make it easier, to make it clear with some electronic platforms. And we practice the exchange of experience, because we as the body, within the facility instrument, we have to protect the EU financial interests as well. We have to see how the EU, for example, how it protects its interests in other states. So we are diving deep in that process, and in future, we want to see the best practices, and we will, of course, apply these, because for us, this is a new thing. And we have the European prosecution and other bodies. Well, and they are tasked to check if EU money spent effectively in Ukraine in a proper way. So the State Audit Service is open to dialogue, and we are in permanent dialogue with civic society. We are very open. You can criticize us. We take it properly, constructive critics. All state authorities are criticized. We understand this, but we try to we try to do the best we can for us to give the best results. Thank you for this opportunity. Thank you. Okay. If you're not criticized in social media, then you don't exist. So, you reminded me, and we now have Yevhen Kostenko from Antimonopoly Committee in the Olha, and people from Ministry of Economy and Denis, I want to share some good news with you. Thanks to openness, communication, and functional transparency of Antimonopoly Committee and Audit Service and MOE, and cooperation with colleagues, and thanks to systemic, thorough cooperation of Denis with his team, they look for these interesting court decisions. We've generated this fresh product. The review of court practices on 1178 enforcement. And tomorrow we'll publish that on MOE website. And it's already there, by the way, people tell me. It happened today. Maybe because of our conference, maybe no, but who knows if there's any connection. Thank you, dear colleagues. This is thanks to this cooperation, we managed to do that. And right now, I'd like to pass the floor to Olga Nechytaylo. She'll join us online as well, and we'll talk about the role of Anti-Monopoly Committee, AMC. Everybody thinks of like AMC as the appealing body, but okay. We'll also think about we'll also talk about other functions of this committee. So Olha, are you with us finally? Thank you so much, Oleksandr. Thank you so much, and truly, I'm so happy to be the part of this conference, be at this panel. So my speech will be built around the PP reform issue. So EU acquis alignment, and also, of course, this is important. In the context of two key functions of AMC, may we have the slide? Yeah. So we'll talk about Anti-Monopoly Committee on the one hand as the body for the PP appeal procedures. Why do I take this function as the first one? Because in fact, the appealing body is the starting point, the entry point. When the committee as an institution stumbles upon the procurement procedure, when we can observe some potential, let's say, conspiracy or manipulation indicators. Anti-Monopoly Committee as a competitive institution. So we'll talk about practices, Ukrainian practices and cases, the intentions of Ukraine to tackle such dangerous things, such dangerous violation as conspiracies at auctions, bidding procedures, and competitions. So we come to the first role, the appeal. And I just want to note here, maybe just to show off slightly, that AMC, the committee, is performing this pre-trial appeal body in public procurement since 2010. So we have huge experience in that sector. And this model was picked as alternative to ensure that we ensure timeliness, specialization, and accessibility. So it complies with the recommendations of the EU and OECD, and there are advantages of independent administrative body to handle the procurement disputes. We all know about the legislation, the law on public procurement, and bylaws providing details on all the procedures of complaints, like how to file, what are the templates, deadlines, penalties, everything. All the details and nuances are there. According to Article 18 of the law, any participant of procurement procedure has a right to appeal against actions, failure to act when it comes to requester if this procurement activity violates one's rights. So, since 2023, well, you've all known that. You'll know that. You know what? We had certain institutional reforms, small one, within the Anti-Monopoly Committee. So we introduced the authorized person's institution within the appeal commission. So certain functions were delegated, and these people make decisions on certain requesters' actions. Why did it happen? Why did we delegate those? Because the demand that we have in the market when it comes to contesting, when it comes to appealing, the demand for justice is huge. And we know very well that Prozoro's system, we all see everything in the system, it stimulates this demand. It expands it directly because subjects can read the whole information there on requesters' actions, and everything can be checked on competitors' actions. It's pretty transparent. This demand is also stimulated by the procurement ecosystem because we can see today in the hall and in the panel we have so many controlling bodies that actually oversee the process for procurement to be actually transparent, effective, and just. So business feels this. Business feels that there is an intention and aspiration in the state to ensure these principles, to make sure that equal attitude, optimization, and justice principles. So this also is reflected in the activity of our business players when they file their complaints. So one of the peculiarities of Ukrainian model is the electronic template. Via the Prozoro system, you can actually file that complaint paperless, fully paperless, with the use of digital signature and all the stages of from registration to publication, everything's happening online with open access to materials. So we all see everything, yeah? It's pretty clear. And this is an example of the top level of transparency, I can say, Europe. This is exemplary. So I just want to note that this systemic approach to appeal system, to identification of principles and definition of these principles and procedures, it actually helped us a lot at the stage of screening procedure, yeah? Again, I'll show off a little bit and I'll tell you that in my personal opinion, maybe Oleksandr will object this, but in my opinion, Ukraine has successfully gone through the screening procedure in terms of appeal system functioning. So we haven't had almost any remarks, yeah, and it means that we comply with the highest standards. But I'd like to also to highlight this problem. So the fee for complaint filing, as we talk about the basic principles, and I just want to say that this fee is regulated by the cabinet's decree, but maybe in this context, the community should initiate it in front of the government, and the Ministry of Economy initiate the review of the fee. It should be changed because we all know what is the minimum level, what is the minimum threshold, and maybe this minimum fee is incompliant with the reality that we have in procurement now. So, according to the law, the if the AMC agrees with a complaint, the requester has to, let's say, take away the discriminatory requirements. The requester has to change something or to cancel the decision on declining proposal. This is obligatory. But on the other hand, it can be appealed in the court. And only 5% of those AMC decisions go to court. What it tells us about, there's certain stability and the quality of our commission's activity, especially that courts, as you'll see it in my presentation, mostly confirm the AMC's decision. But on the other hand, if we take the recurrence of Directive 69665 with the European Commission recommendations based on these. Ukraine should think, like, where are the possible improvement, windows for improvement, let's say. The next slide. You can see here the statistics for the complaint consideration. And the key message that I would like to bring to you now is that, in fact, so the activity, in our activity, we returned to the pre-war level. In 2021, if you remember, the number of complaints was exceeding 14,000. This is the annual amount. In fact, this was a peak of activity, the peak amount. But after 2022, of course, there was certain drastic decline due to objective reasons, of course, and the rules changed, the appeal rules changed. And at some moment, it was actually impossible to file a complaint because there was 1178 decree. In 2023, 2024, we saw that the dynamic recovered. For the complaints, we returned to the pre-war period. So we actually stabilized. So the participants, the stakeholders, they adapted to these procedures. The economy started recovering, basically, and the whole system. And now we have this demand for justice again. It's the same, basically. It never changed. It's still high.
And the very fact that the public procurement market has stabilized allows us to talk about the importance of new reforms that are important for the Euro integration process and also for the justice system and access to it. As for the efficiency of this complaint procedure, traditionally, as we can see, in 2024, over 7,000 verdicts concerning the complaints, 80% of them satisfied. So most complaints are well grounded, and there were cases of violation, and this is the again, point of reference for our auditors. The next slide. If we're talking about the most typical systemic solutions, again, if we're talking about violations, they don't change. The typical violations are so the deviations from the procedure when there is no possibility to deal with the lack of compliance, and these mechanisms are not stipulated. And in my personal opinion, the norms concerning the rights of a participant to remove these incompliances and again to respond to other requirements of the client. This also simplified the rules of play for the businesses and serves as a preventive mechanism, and that's why the Commission follows the compliance with this rule very closely. And again, this technical part of the tender must be dealt with carefully. So if the participants did not submit the lowest price proposal, again, also the clients also don't follow this rule. And the clients also resort to some excessive demands, and then it creates the conditions where only one specific participant or supplier can participate in the procedure, which leads to the discrimination and to the weakening of the competition. And the Antimonopoly Committee has been talking about it. The third category inquiry is the unlawful decisions of the clients. So when the tender was refuted because of, for example, the lack of documents that were not stipulated and were not the requirement among and separately, we have violations are connected to highly standardized goods such as gas, energy, natural gas, and in fact, standardization and streamlining of such procurements and work on specific components of such documentation streamlined and simplified the access of businesses to the market because they can prepare the unified tender and proposal without looking for complications in tender documentation that the clients really like to add. And however, sometimes the clients sometimes set out requirements that are not stipulated by the normative documents, but artificially limit the number of potential participants, and this is where we see not only the complaints against the violation of the rights of businesses, but also the abuses in the system of procurement, and that's why Anti-Monopoly Committee is systemically upholding the position on the quality of procurement procedures and can optimize it with the help of clear and understandable rules of the game, so to say. For example, it can be standardized standard documentation that allows you to avoid recurring mistakes, and thus the workload for both sides is reduced. When it comes to the number of court decisions, the complaints against the decisions of the Anti-Monopoly Committee, or this share of such cases remains very small. So in 2022, we only had 200 decisions out of over 20,000 was again complain again where went to court, and only only in one case the court annulled the decision. So some cases are in the progress, or some cases when some claims were not satisfied in this case, and which means that in most cases the position of the Anti-Monopoly Committee finds its confirmation in the court practice. Then I'm going to talk about the key areas for future improvement and of the complaints in the field of public procurement. Please change the slide. So especially important is the first block, which is connected with the euro integration obligations of Ukraine. And it reaches a high level. And again, we have the Directive 8965 on the legal protection in the field of procurement. This is where we have some work to do, and at the screening meeting last year, we were assessed highly, but we got our home assignment. The major technical technical aspect which was not in compliance is removed by the legislative initiative that is promoted by the Ministry of Economy and which is now looked into by the Parliament. So we are talking about all types of procedures now, so that the deadlines should be no less than 10 days, and uh, the the European tenders are subject to correction. So we see that we will have a large number of procurement procedures that are new for Ukraine, and the complaint system must cover them too. And the European Union also drew our attention that a large number of procurements is done with the use of electronic catalogs, but there is no system of complaint in this case. So this is also the case for Preserves, for the Ministry of Economy, and also with the central procurement agencies. And it is no secret that if you want to contest this in the court, then again for the concessions, and it's also the case where the cases stay in court for years, and the whole procedure is ineffective. So since we're talking about the court, this here we see the special function which could be improved upon. Thus, we should note that the system that the European Union member states follow is built on the principle of quick review of decisions by administrative bodies that ensure the complaints procedure in its first stage, and our court system is built in a way that such questions are looked into according to the general procedure, and the duration is rather long. Therefore, maybe this could become again the subject for our common effort. On top of that, the adaptation of legislation also stipulates the use of the procurement legislations, and this was the priority of the Anti-Monopoly Committee. We are looking at the general practice, and we issue also the explanatory documents that you can find on the website of the Anti-Monopoly Committee. But what's even more important is that in general, the experience that this experience can be scaled up for those IT tools such as auctions, competitions, tenders. But unfortunately, in terms of procedure, this system of pre-court stage is not stipulated. So one of the objectives of the draft law could be the question of implementation of pre-trial complaints and the optimization of the procedure when there is a privatization procedure, and the Anti-Monopoly Committee will be an independent and effective arbiter for a large number of agreements that are concluded by the Fund of Government Property. And I also suggest that we look at the function of the Anti-Monopoly Committee as the special kind of agency. Here, again, we have a case where there is the system of competitive right, and since 2021, we have the ban on anti-competitive acts, but as the practice shows, despite the ban, the participants of the bidding sometimes are in collusion, and that's why it causes damage and to the bidding procedure. And so we see that there were over 6,000 cases of distortion of the results of procurement procedures such as tenders, the auctions, bidding, which also shows the systemic risk to the economy. In fact, the Anti-Monopoly Committee, as a body that is responsible for competition, is very careful in this respect, and our statistics shows such attitude. Next slide, please. We have the dynamic of such collusion that result in the distortion of the results of the tenders. We see that the numbers are high, and we are aiming to increase our activity here. So the issue of collusion at tendering procedure remains, and so transportation services, fuel, energy, and also the field of healthcare, the fields in question. The next slide. So thus we can say that we have a clear signal the socially important fields are susceptible to such collusions. That's why we need the cooperation between law enforcement bodies and international agencies to improve the situation. So to your right on the slide, we had the procurement procedure for the medical equipment, so the ventilators that Ukraine needs to combat COVID-19 pandemic, and again, we use it as a special evidence, and we used a special economic analysis where we showed that the participants and how they could compete within this auction. And the next slide, please. Another case is that connected with the diesel fuel, and what's important to underline here is the scope, the scale. Two participants actually staged the participation in 24 auctions. And secondly, as you see, and the Anti-Monopoly Committee approaches this based on the whole body of evidence. One piece of evidence is not enough. We need as much evidence as possible to provide the comprehensive picture that will prove beyond reasonable doubt that there was a case of collusion here. And in this context, I would like to note that investigations are often effective if the committee cooperates with the National Police of Ukraine, the Prosecution Office, the Security Service of Ukraine, National Anti-Corruption Bureau. So if the pre-trial investigation bodies have this information, and if we find this information, so we add it to the materials of the case. However, it should be underlined that our effort also focuses on the evidence basis and the synchronization of the practice with that of the EU, which also stipulates the additional tools for collection of evidence. Thus, there is a need to conduct checks, to conduct audits, to obtain information from electronic means of information storage, where we could find the proof of violation of legislative provisions. But this access can be obtained only with the help of active procedural support from the law enforcement bodies.
And the next effective tool on how to collect evidence. Can we have the next slide? So we really hope that the program that we launched last year with the help of the reform and with the draft law that was adopted by the Parliament in 2023, very powerful tool that is functional in all EU member states. How it works. So in fact, when the subject is a whistleblower, for like any cartel or conspiracy, one can get like full exemption when it comes to liability or partial exemption. So a discount, let's say, a discount for the penalty. Discounted penalty that is imposed depending on the quality of evidence and depending on, like, if one was the early bird to inform about any collusions or plotting. Okay, so I really want to encourage all interested people, please stimulate the subjects. If you know, for example, that they are engaged in illegal activity, please use this program because it's already functional. And already 2 decisions were made based on these applications. So 2 subjects were fully exempt. And the next slide. As I mentioned multiple times, in antitrust sector, we focus on development of the tools, improving its quality, effectiveness, and 12440 draft law is the basic one. It's the basic document that actually ensures full alignment of AMC activity in terms of investigating with the EU standards. So we get additional updated toolbox that will allow us within shorter terms to investigate any violations and breaches. Okay, and the very last slide, I guess. Yeah, conclusions and plans. So just to finish, I want to say that, yeah, you can see that we have 2 blocks, 2 areas where we should put more effort. So we demonstrate these efforts to you as to public. Please engage to those. Like, we would like you to check if the tools are implemented effectively, demonstrate these your integration, manifest your integration intentions, European Commission. And we got some really positive score, some nice score within these chapters, within some selected chapters. But of course, the homework is still there. We have to do that. So, Anti-Monopoly Committee will be grateful if the procurement community is engaged actively to legislative initiatives, to discussions, public discussions of the drafts that are about to be produced in the next couple of years for our legislation, for our framework, for our regulations to be just, improved. Sky's the limit. Thank you so much. Thank you so much. This is definitely a great speech, and we will, of course, we need to dig deep and to pay more attention to collusions, conspiracies, and plotting. It's the biggest art is to prevent and to hold those liable. So we've had 3 key speakers from the controlling bodies. We will have a small maneuver, and we will have some external assessment of the situation. And I would love to pass the floor to Ms. Inguna, who is the team leader of Component 5, External Audit and Parliamentary Control of EU for PFM. And by the way, Ms. Inguna, she is the former leader of the State Audit Service or Office of Latvia. Yeah.
It's my pleasure to give greetings and presentation to such distinguished audience. I choose topic the role of external audit and meaning Supreme Audit Institution in public procurement, and I define this role as ensuring integrity. Why public procurement matters? It's really heart of public spending. And the need of oversight is very, very important. And if we are looking on public resources which are going through public procurement, oh, I got English, it's good. Okay, thank you so much. When we are looking on size of public resources which are going through public procurement, it really matters. It's approximately 30% of spending which is going through procurement procedures, and this is very vital funding for public services. And I'm calling public procurement as engine of public service delivery and cornerstone of any economy. Looking on size of EU countries, approximately 14% of gross domestic product. If I compare with size of resources which are going through public procurement procedures, which is approximately 14% of GDP of EU countries. And ensuring integrity in this system is really very vital. And it's vital for public trust and for effective use of resources. And auditors very often is called as watchdogs of public spending. And their role in these processes are ensuring that procurement processes are not just legal, but they also ethical and effective. For Supreme Audit Institutions, it really matters what mandate they gave. And it varies country from country. And recently, Accounting Chamber of Ukraine, which is Supreme Audit Institution in this country, at the end of last year, their mandate was significantly increased. If before, Accounting Chamber was able to audit only central government resources, now their mandate is extended to local government resources, to state-owned and locally owned companies, and also matters in which legal framework country operates. For EU countries, of course, these are directives which guide any procurement process. In this country, there are local legislation. It depends again what legal framework has in country. This is what Supreme Audit Institution uses when they audit public procurement processes. And in which way these audits are done? It's mainly compliance and performance audits. And always, very often, and in most cases, subject of audit is entire procurement process, starting from needs definition, how these needs are defined, when going through process of how contract is awarded, and again, through whole process, how this contract is completed, how this procurement is done, if it's public goods or it's public services, to final stage of process. In compliance audits, Supreme Audit Institutions ask questions how these procedures are adhered to legal framework. As I said, in EU countries, it always will be EU directives and regulations. In local context, it will be legislation which guides and defines how these procurement processes should be defined. In performance audits, we go further. We assume that processes are legally correct, that everything is compliant. But when we ask questions about economy, efficiency, and effectiveness, it means if with the same, if we ask economic question, we are looking if the same things could be procured with less resources. If we ask efficiency questions, we are looking is with the same resource we could deliver more goods and more the same higher quality services. And effectiveness, it's about this, how goals are reached. If we used goods and services to deliver some function, if really with this instrument, with these goods and these services, these goals are reached. These are called 3 E's, which are asked in any performance question. It could be audit which are looking only on economy. It could be audit which looking only on efficiency or only on effectiveness. About key questions in any audit when auditors are auditing public procurement processes, the core questions usually will be, is the need valid? Is the award procedure legal? Are resources used appropriately? And aims differ. Again, it depends on type of audit which is chosen. It could be also, even during financial audits, looking for compliance of financial statements, but some processes of procurement are checked. But also looking on how performance of contracting authorities are done. It could be like several activities of contracting authorities, looking on efficiency of these activities. It could be aim of audit evaluating competition, evaluating value for money, and could be aim also in audits looking for public procurement, how these procedures could prevent fraud and corruption. If there are some inconsistencies in the way how these procedures are defined, then there could be risks of fraud and corruption. When we look on process of public procurement as auditors, I will just quickly stop on these key steps. As I said, everything starts with needs definition. It means that mainly auditors are looking how internal processes are set up. Because also for ones who are organizing in institutions, every institution organizing public procurement, all of these requirements should be justified. Everything should be written on paper. There should be procedures. There should be calculations. There should be assessments done before an institution is going further with procurement. It means that when auditors are looking on these needs adjustment, they are looking for these calculations, for these considerations. Always it's important when an institution came to decision to procure certain goods or services, if they also assess some alternatives. When we are going to next step, which is awarding the contract, when mainly comparison goes on external process, how it's governed by law, in case of EU by directives, and looking how these core principles of EU regime are implemented. And I will just mention them. Competition matters in open market and common market of EU. Non-discrimination is very important as principle in any procurement process. Equal treatment of participants, that everyone has the same rights, and there are no special rules defined to give a proposition for one or another contractor. And what is very much matters, it's also transparency. In any, of course, procedure, transparency matters, that the information is available to everyone, it's open to everyone. And auditor's role in this process is to verify adherence to the spirit and rules. And formal rules ensure equal treatment. It's very, very important, again, that everything what we audit, we are able to audit rules which are on paper. If there is something which is not described, it means that there is possibility to play some games, to not be to introduce rules which are not competitive, which are not equal to each participant. And going to next step, which is awarding the contract, which is one of very, very important steps, as you know, is finalization of procurement procedure and before contracting. It matters how performance is described. It matters how contract value is defined. Also, transparency, clearance, and preciseness of any tender documentation. And as in any contracting procedure, award criteria matters very much. Award procedure, notification, and assessment of tenders. Everything should be documented, everything should be transparent and available for auditor. This is for what any auditor is looking. And also auditors focus in these procedures on ambiguity, non-discrimination, objectivity, correct procedures, and transparency. And again, I'm mentioning transparency is very important and key in all these processes. And as any procurement process, it ends when any institution receives procured goods and services. It could be a long process before maybe works are completed. If we are talking about construction, auditors could step in audit mainly on two phases. Just in phase when needs assessment is done before contracting procedure, but mainly it's already looking at the execution stage when procurement is executed, when goods and services are delivered, looking when on whole process, how this process was done. And on stage of execution, as you all know, when contract is signed, it's very, very important that there are minor modifications to that contract. If the contract requires very important modifications, of course, it should be that there is new tender process announced, but only in limited situations it's allowed that there are some specific circumstances, some emergency cases when contract modification is done. Also, auditors are looking on payments, on time payments, how warranties are implemented, and comparing any shortcomings, what could be in process of execution of contract. And auditor's role on that stage of contract execution is to look how compliance is implemented in process. Audit compliance with modification rules, this is what auditor is looking for. On audit subject, mainly, of course, always, in more cases, it's individual contracts, but I know that in this conference you spoke also about other procurement, contracting possibilities, that it's not only individual contract, it could be also framework agreements, and again, also in cases auditing framework agreements, it matters as award procedure, as appropriate use of this framework agreement, is also scope what this framework agreement covers. It could be also such legal procedures, concession. I heard that you'll be discussing also public-private partnership. It's not maybe so much used here in Ukraine, but I could say that some years ago, several Supreme Audit Institutions did common audit on public-private partnership, and unfortunately, they never find any success case using public-private partnership, because also for this contracting procedure, using this instrument for implementing mainly construction works, it should be that it gives economy instead of government procuring itself and using individual contract. But history shows that always, unfortunately, it's more expensive than if government was doing itself this construction work using individual contract and paying directly and taking money from market, not involving money of private sector for delivery of that service or goods. I wanted to use as example one of a special report, which is audit done by European Court of Auditors. It was published recently, just in 2023. It's a pretty new one. And this is why I wanted to use this example, because it's interesting that European Court of Auditors did this audit comparing the situation with public procurement in basically in all EU countries. And what EU auditors find out that competition is declining in EU public procurement, and key findings of EU auditors was that public procurement, of course, is crucial for EU single market and in achieving value for money. I said that looking on EU market, when approximately 14% of GDP is going through procurement procedures, and auditors find out that over the last decade, this is up to 2021, competition for public contracts in EU has decreased. As you know, maybe that in 2014 there was some reform in EU directives related to procurement market, procurement procedures. Some directives was changed, there are new directive introduced, and it all was done with goal to even opposite, that there is a larger competition, that small and medium-sized enterprises could participate, that there is more assessment of sectors before going for procurement procedures. But unfortunately, in that audit, EU auditors their findings was that this 2014 reform on EU directives has not reversed this trend, and that there is also general lack of awareness regarding the importance of competition in public procurement. EU auditors, when they did this audit, they used all publicly available information, and it means that they've been able to assess how market works and find out that there is not enough publicity, not enough transparency. Their findings was that Commission and also countries, they are not put right attention to these processes. What else they identify? They identified that a significant increase in single bidding and high level of direct awards. They also find out that there are limited direct cross-border procurement. And as I said, that these 2014 reform goals on simplification, access to small, medium enterprises for public procurement, strategic use of public procurement, that these goals remains largely unmet. Again, that what was a reform issue to make lower these administrative burdens, but unfortunately these administrative burdens persist for bidders and authorities. What matters for procurement and using taxpayers' money for public goods and services, but also such aspects as environments, social innovation are assessed and used. It's again consideration of auditors that they are really considered. What is also for me unfortunate to see that for so many years looking on that everything should be more and more transparent. When I read this report, that I saw that auditors considered, and in their findings is also such finding as low publication rates, which negatively, of course, impact transparency. And publicity, this is safeguard against fraud and corruption. And in this way, if ones who are using taxpayers' money for goods and services in favor of public, we are not transparent in way how they are using this money. Of course, this is not good signal. Even it was found out that some reform objectives may even reduce competition. It means that Commission should look on rules what they introduce if they are even worsening situation in market. what is core problem addressed by this audit report, that insufficient attention paid to competition by Commission and Member States, and that there was a lack of actions from Member States side as from EU Commission, but data not systematically used for root cause and analysis and only scattered actions taken. And as I already mentioned, that these auditors worked mainly with all data which are publicly available, and they've been able to, from this data, to get to such conclusions and show situation in procurement market. And the auditor's role, of course, is in this audit, these findings underscore the vital role of auditors in highlighting these issues, pushing for better data and analysis, and they verified that recommended actions are implemented. And always any audit finishes with recommendations, and these are recommendations which have been given to EU Commission and Member States in that sense. Mainly, I will mention just key of them. This is called for action what auditors ask EU Commission to clarify and prioritize public procurement objectives, improve data collection, like close gaps, improve accuracy, enhance monitoring tools for better analysis, and deepen root cause analysis and develop an action plan to overcome obstacles. Of course, I'm not able to follow what happens afterwards, but usually after audit, some years later, this is practice of Supreme Audit Institution to go and do follow-up audit, and probably when maybe in some coming year could be also analysis coming from EU auditors related to implementation of these recommendations by EU Commission. I will conclude with my short presentation. Why this external audit matters. It's really a very important tool, independent tool for scrutiny and accountability. And external audit, it's powerful tool for promoting integrity, efficiency, public trust in public procurement. And external auditors, their work strengthens the framework for fair competition, value for money. And this independent view gives also public assurance that their money is handled responsibly. It's very, very important to any taxpayer, but there is independent scrutiny who gives this assurance what is happening with their money paid. And auditor's role is to be this independent assessor. And I know that colleague on the left spoke about State Audit Service role in this country. It's also very important, but if I'm talking about Supreme Audit Institutions, and it's also in case of European Court of Auditors, when we all operate in the one legal framework. It is international auditing standards, industry standards, but everyone understands how our audits are being performed. But also our mandates, our principles which we follow, that we are independent from executive, independent from institutions what we audit, but we have enough resources, but we have professionalism to do this. And our independent assessor's role is to provide these crucial insights to public bodies, to keep them accountable for their procurement decisions and drive continuous improvement. And ensuring integrity, of course, it's not only role of external auditor. Ensuring this integrity in public procurement is shared responsibility. But what external auditors are doing in this process, they provide this clarity, accountability needed for all stakeholders to work together towards this goal. It means that information about external auditors are giving. It's not staying only in their files. It's all public. It's shared. It's always discussed with stakeholders. In case of Supreme Audit Institution, main stakeholders is Parliament, and it's very, very important that also stakeholders using that information, looking on necessary changes in legal framework, looking on ways how public sector institutions work themselves, what is needed to improve their performance, because everyone is accountable to public, to ones who are paying taxes for these goods and services. Thank you so much.
Дуже дякую, пані Інгона.
Thank you very much, Nguna. And as we have seen, the issue with competition is quite clear, and it is good that the European Union also talks about it. And one of the many tools to help it is actually for Ukraine to join the EU. We have active businesses, 12,000 complaints per year. That is already a high level of activity. And our civil society that is not just active, it is very well aware and well qualified, very progressive in its response to any violations. And today we have an exceptional situation. Instead of two speakers, Denis, I will ask him to focus on what Maxim wanted to focus, namely the specific features of procurement for construction, which is connected to rebuilding and reconstruction. An important aspect is that we use funds from our partners, the European Bank of Reconstruction and Development, the World Bank, our partners from Korea and Japan, and others, and larger portions of this funding goes through Prozoro. And again, Denis, now nothing prevents you from sharing your observations from the public control field. And it seemed that the most speakers, live in the world of My Little Pony, and now I'm going to bring you down to the Gotham City. So everything that we built, we are using as so-called supramodel for it. We analyze per year several thousands of procurements, and back then we understood, and we divided all those who commit violations into categories. The first category is those who are not attentive, are not aware of the law, or not careful. The second are those who know but are afraid of violations, and the third category is not care. So the first category, if people are not attentive enough, if you change the system, and some changes have been already implemented, and again, saying hi to Prozoro on the Ministry of Economy, e-contracting, electronic tender documentation will help reduce such violations, and I hope that in the coming years they will implement it on the level of legislation. So this share, thanks to Prozoro, it dropped, and we detected that this is the 15% of such violations, and there's room for improvement. And the second aspect, when people commit violations, but they are afraid of punishment. So the partial aspect goes to the State Auditing Service. If we're talking about statistics, the auditing service analyzes, carries out thousands of monitorings, and they detect violations violations, either 5 to 7,000, depending on the year. But if we're talking about the fines, it is 50 fines per year. So if only 1% is being punished, so who's going to care? But even this monitoring impacts some of the clients, and they change their behavioral patterns when auditors start doing their job. But it's not enough, because the clients understand that nothing's going to happen to them. So then they become careless, and we need other measures. So those who commit systemic violations, Kamyanska City Council, you won't find a department who is afraid of anything. So they don't care about the police, the prosecution services. So the format, what it comes to, when we're saying that there is a violation, then, during the last year, we opened criminal proceedings of approximately 120, and 100 of such cases are in the police. And when we come to the police in such a format, we analyze them as per acts. So we compare the prices with those on the market, and if it's over 20% difference, then from 20 to 300%, this is what we see across the market. If there are substantial deviations, we notify the authorities. Again, for the last year, 600 million of artificial increases. So if we are just to calculate it roughly. So if we are talking about systemic abuses, for example, the water pipeline, all the there was a case like that. The cost of pipes increased twofold, so 129 millions price increase. They say to NABU that they won't give them anything. So the complete nihilism when some agency does not provide any documents to the National Anti-Corruption Bureau, so we have to use special forces to obtain the documents, and respectively now everything. All the information is collected, and again, if somebody allows themselves acting like that, then again, you can work with such clients when they are under suspicion and there is the threat of a real punishment. And the system works slow, and you should understand how we work. Our format encompasses 4 regions: Dnipro, Zaporizhzhia, Kherson, Mykolaiv, and we are analyzing procurement procedures there. To give you more clarity about the scope of the issue, if we're talking about rebuilding and reconstruction, we're starting with 30 millions, and in every procedure we see increased prices. Where every second procedure where there is the European funding or subventions from the state budget, and now, unfortunately, the auditors do not check such price increases. The only person, the only bodies that do it is the police and the National Anti-Corruption Bureau, but it takes years. So it could take 2 years, for example. When we now we do act differently. So when some part of acts are signed, we open the provisions, we open the case, and so that at the stage of the next payment, we could hold these perpetrators to account, not only businesses, but the whole chain of actors involved in this violation. Partially, we are successful at it. So what can be said, for example, in Dnipro, we had a children's playground over approximately 55. So in 2023, there was a twofold increase, and in 2024, there was it increased even more. So it is a local councillor who's doing it, and plus 7 people, plus businesses. So everyone is on suspicion, and the case is in court. So respectively, when we still can catch it at early stages, we can prove it, and it's moving slowly, but depending on the field where it happens, because in Mykolaiv Oblast, everything's difficult. It's easier to work with the National Anti-Corruption Bureau because the police is not that effective there. But again, the changes are possible because
of
What Ivan said, we want all the acts starting from 10 million to be published. Why? For, let's say, NABU to be able, without just silently take this out of the system, and register these violations early to make sure that these people are held liable. When we saw in some aspects where we, together with law enforcement, where we actually led this process to courts, and proceedings, of course, it prevented the following corruption risks. So the money transferred to other area or lesser violation. Speaking of Dnipro, with the defense procurement in the city, they had 6 suspicions. After that, the situation changed drastically. Nobody was ready to manipulate. Nobody was ready to violate the rules after this. So when the situation becomes public, when everybody's aware about that, it helps law enforcement, and of course it affects the officials. Meaning that, okay, when I speak of this group, they know what they're doing, they know the law, and they have the systemic corruption. When there is public awareness of that, the next procurement cycle, they, with the smaller corruption margin. So publications in media, publications in social networks, these can help, these posts can help, to change the situation. For the money, at least, in the next procurement, to be spent in a better way. But we still have a lot to change. When we talk about the recovery portal, Max Nefedov and the team, they also go physically to the objects, they check what's happening. Why it's important to have these field trips? For example, in one of villages, they built a hospital, let's say, and they repaired a school. And according to the documents, they finalized everything. When you come there, you see only the half of the school made. You walk in the hall, there are tiles and special tiles with visual impairments. And in the middle of the hall, you bump into the wooden floor of 1960s, and then the tiles are cut in the timber. It's there. on the right in the hall, you have a sink without no water supply. So it's like the object is finalized, but in papers, but de facto it's not. So this portal helps people to notify of these cases, and to check the situation physically, to change this, not to manipulate, and to avoid any fraud eventually. Because quite often, what is the abuse? What is the most typical abuse? They change the format of the materials that they use. When they use the tiles in the yard, you can see when they unpack the pallet, with these tiles, the slabs, you can see the brand and you can see the type. And some brands are just cannot withhold the resistance when vehicles are above it. So in half of the year, it's just destroyed. But according to documents, if we speak about the project that is uploaded, in documents, they put like tiles with proper load bearing properties and so on. So we analyze the acts, we analyze the documents, the budget plans, of course, we do that. And the inflated prices compared to markets, so we call to a building supermarket, construction supermarket, we compare the prices, and the MOX team and anyone can actually engage to just visit the object and check. Because only 1/3 of objects is our capacity. We can check them physically and see what is used there and what is the situation there, literally. So this combined format, maybe this can save money from the state budget, including the loans provided by international partners, and everything can change. But as I told you, these 3 blocks that I consider important. First, when people are inattentive or they are not aware, also improving the system with these digital lines filled in automatically. And it's also important to optimize the State Audit Service and accounting chamber activities. So they're improving, but still, sky's the limit. And police in NABU must be very effective in that. That's where everyone can help with the public pressure, of course, because sometimes police tells me, okay, put it in your account, make a post, because otherwise this can be just neglected. I'm done. That's all. Well, I don't have a lot of time, but for now it's done. It's done. Yeah. I finished. Alrighty. So we started with pink ponies and then yeah. Okay. And instant feedback. Well, the Kamenskyi and Dnipro examples, these cases tell us that these really great big complaints from local governance that central level is limiting them, it's exaggerated, at some point. This is some sort of a nihilism, as Denis said. So they tell about it. Maybe it's interesting to try to unify the approaches, not only when we identify the cost of the procurement, because usually it's the root, the procurement process, agreement conclusion. So this maybe will help to establish a new centralized organization in construction procurement, for example. The decision was made by cabinet in the beginning of April, and Maxim, by the way, had to tell about it. When I see those videos, the public presentations of this event, and Mr. Sukhamlin, the head of agency who was promoting this idea, he also noted that unification of this practice can be useful for other requesters as well. And municipalities, these are the first categories. They are not aware of the law, and for them it will be possible to talk to this body. Denis, your opinion. Are you ready to engage, actually? Are you ready to help this body, central body? So this is like experimental approach at some point. And maybe it should be supported. to make sure that certain centralization in construction procurement is possible. If it's possible, for challenges related to recovery, this would be an interesting solution. We are ready to engage, of course, but the key question is for the body staff to have proper wages, because when we launched that in Kharkiv and the wages were 3 times lower than in Kharkiv market, like we understand that it cannot work as it should be diligently. So the actual implementation, it's interesting for me, how will they actually do it? We're always in the scope of our capacity, we're always ready to help, launching various interesting things, useful things, because it seems to me that CPA can handle the recovery in total, enough of staff, but not, this is not like the unlimited number of staff, of course. The control will be easier, be simplified, because the format will be clear for everyone. You will not have 10 entry points, because currently Europeans cannot say how money are spent in Mykolaiv, let's say, because money allocated via donors, but the control formally at the level of audit service in Mykolaiv or police is very weak. So they have to either create the structure there, control it there, or the CPA in Kiev, and subordination to NABU, and then the staff will act as it should be done. Okay, very clear message. It will be easier to enter the CPA in Kiev compared to Kamensk, yeah, and work. Yeah, I just want to tell you that by May 28, we still have the competition for this CPA head vacancy, and on the website of Recovery Agency, there's some information. We also have some competition for new vacancies, the members of the accounting chamber also, and we are in the process. So this session is not only about what's happening now, but also is that institutionally we are strengthening the capacity. New people will come, new blood, and this is important. So my call to everybody, it was an interesting session, and there is something to say, maybe not just questions, but reflections, if you want, of course. Maybe you want to grab the mic. Not forever, of course. Hello, Yaroslava, public procurement consultant. I have question to 2 people, okay? First, the question to the State Audit Service, 2 questions. On the procurement with Ukraine facility tool, according to agreement, there is exception when we can buy from the countries of unaccepted countries and goods from unaccepted countries. Did you work with these mechanisms? How will you control these procurements? Okay. What can be a justification for you? Because framework agreement tells that in some specific cases, but we still don't have these amendments, and still requesters procure. Do you have internal methodological recommendations, or maybe you will publish it? Because people should know about your approaches, all of them, participants, requesters, and liability. You plan and you lobby the increased liability, strengthened liability, administrative responsibility for authorized people. I understand that this is maybe not your competence, but maybe you discuss this with an authorized body on how to increase professionalization and how to motivate people to function in this area. I'm a lawyer, and when the liability goes up, it means that motivation should go up. Wages. Let's start with that. So do you actually think of higher wages for authorized people? Maybe Oleksandr can pass this question to someone. And question to you also about control, post-control. How to hold the head liable. You said this is not going to be the authorized person, but the head who will be head liable. But one cannot affect the authorized person when one is in the public procurement. And when you had the monitoring, when you published the opinion or the inspection act, so the head is responsible for the whole organizational activity, but one cannot affect the authorized person. And it's like one should affect for authorized person to act according to opinion. So will you separate this responsibility? Maybe the authorized person should be responsible as well, because it's not about declining the proposal and that the opinion is neglected. And those people who actually enforce the agreement, those officials. But it's not about the agreement, but the non-declining of the winner. So the authorized person should be responsible. My question to Denise, and Ivan maybe can answer that. This third group that you said, like those who don't care, this is the most interesting for the state to have fewer of those, because budget money, a lot of budget money are lost, because of those. Based on the results of your measures, you identify inflated prices, and situation improves because prices go down. But I liked your example at the same time when you gave this example, Max's case, when you were walking there and you saw the timber floor, the tiles, and no water supply and whatever. It's your example, yes, but it's a project of Max, yeah. So failure to perform the works, low quality of materials, partial failure. So maybe there is a connection. You prevented that, you decreased the price, that's why you have that tile or timber, or there is no water supply. Like, you report that yes, we prevented that, price is lower, requester said yes, but did you study it further, all the procurement? What did it lead to? We have the example, that's beautiful, but when this is public financial control, when auditors check that, they don't only check that, they don't only have the desk inspection with the prices, but the actual process. They look at the tiles, they look at the parameters of the tiles, if everything is done properly. Maybe you don't have the powers. Maybe audit service should handle those cases where the prices are lower, for the public to understand that they don't just decrease the price, but that's what they could buy. So maybe there was no need to lower. Maybe Ivan and Denis can think about it, okay? This is an important question. And the control consequences is a whole philosophy concept. Thank you for the question. We start with the last question. About administrative responsibility. Honestly, the amendments in the administrative code, it should be there. These are evolutionary. These should be already put there, because the new law on public procurement does not stipulate automatic amendments to administrative code. But with the spirit of the law, we need to have those amendments, because these are new procurement methods, many new stuff, many new things that have to be, we need to rethink it and apply it properly in the administrative violation code. So we have tight cooperation with the Ministry of Economy, and we have proposals. We work on that. On the responsibility, the failure to meet the legitimate requirements of the financial control body, we have to, that's what I mentioned. This is a matter of discussion. We think about it. We can see the so-called, it's a gap, it's a huge gap. Those billions of money that are currently used against the law on public procurement. It's contradictory. You cannot do anything but just to talk to police, basically, to law enforcement. But when we talk to law enforcement, it's not 100% protection for the budget. We can't protect the budget from further waste. So there's a risk. Unauthorized persons. One example. Let's take one example. What is the logic? So the agreement is not concluded. Audit service is obliged to decline the winner because one is lousy, let's say. One is not declined, but who concludes the agreement then? Who has to control the who has to control that? Yes. What authorized person is responsible for and what head is responsible for them or the manager. But this is for the legislative justification. And for certain and how to identify the violation. But the manager is responsible for failure to perform. Okay? So the duties of the authorized person are limited. Then the agreement is endorsed with all the structures and departments. Authorized person can sign that with a requester, not necessarily a manager, the one who has a special right for that. So all these things we're analyzing now. We have to strengthen responsibility. And primarily the managers must understand that you do not need to leave your authorized person alone and to be abandoned. Then the authorized person. We always stick to that idea that authorized person has to be a sort of one who's fighting corruption, anti-corruption officer of the enterprise, legally protected by legislation from consequences of one's actions. If this protection will be manifested in this high wages, or if these are certain like labor guarantees, I don't know, if this person shall not be fired upon the initiative of the manager, or some special protection mechanisms if there is pressure, external pressure, it's not for us to decide. So we do not shape the state policy, but in this aspect, we support that authorized person has to be super independent, super autonomous to professionally perform the duties.
And how they could do it, what is the satisfaction level, that is not for us to decide, but we support this idea. And if you are responsible for something, you should enjoy a level of legal protection. And when it comes to Ukraine facility, the agreement has a condition that there must be some exceptions where you can refrain from using these requirements. So now we are in contact with the Ministry of Economy. We are working on this issue, but if we are to read the framework agreement, it talks about the exceptions, and we must figure out what they are. According to the general idea, it is the framework agreement that lists all the procedures, procurement procedures. We understand the requirements of the EU. If everywhere we mention procurement procedures, it means open procedures. It cannot be an open contract, and because the contract is not and because catalog is not a procedure. So we have this story on these legal contracts, and this would be the risks for Ukraine. It cannot be just one party responsible. This will be our common responsibility, ours and yours and that of the government. So this is the real case, and what to do with it, we don't know. The funds from the facility, the food, our Rivne Oblast concludes as in accordance with the catalogue, and the private entrepreneur is mobilized. They concluded a direct agreement, and whether they violated this conditions, no, because they need to provide food to children, and maybe from the viewpoint of Ukraine facility, it's wrong, and maybe again this is the risk that the children will be hungry. So there are stories like that. So this person, this entrepreneur was mobilized, and we understand that these are risks. But now, no auditor during the auditing again will tell you that you violated this condition, because there is a requirement from the law, but there is no implementation for it, so there is no normative regulation of it, and there is a discussion where everybody's looking at as for the pricing in construction industry. So the auditing service disagrees with how the pricing in construction industry is done. But if we're talking about the construction industry, it means large allocations. Others are just goods and services. So the issue here is in the legal regulation, in the pricing, and it is the central executive bodies that is responsible for it in terms of pricing. So if such a state policy allows us to purchase the pipe like that, and again, we are in communication with them on this with respect to this issue, and maybe partially some of the issues will be resolved, but if in general we don't sort out the pricing price formation in construction branch, then again everybody must understand how it's formed, and we can have a separate conference specifically focused on building, and the state of play is not acceptable, and we are doing our best to correct it. If we are talking about the aspects of control and all other things, so if it's reconstruction, if it's a school or a hospital, when the bank says that that they must be guaranteed by the banks, and then some clients abuse this norm. So if the contractor is dishonest, then again this bank guarantee can help. So if we're talking about the analysis, so we every 6 months, if we see a big risk, we go back to this. So it is. We also are looking at those facts where market prices now. And you can correct the acts of services rendered, but so a specific sum of money will go back to the budget or to the account of the client. But if the prices were increased, and when people agree to reduce those prices, it means that that second group that are afraid of punishment, and there are those people who do not reduce prices and go until the bitter end. And we won the court case in Kamensk. And when they say until the executive service comes to us and and takes those documents, we won't provide anything to you. So they are not afraid of fines. So 84,000 hryvnias, but they, for example, increase their prices by 5 million. So who is going to be afraid of that? We understand that this difference is covered. So the aspect is that because Ivan, say, a guy named Ivan came to school and they reduced the prices and they didn't finish the construction because it's the approach of dishonest contractors and their unwillingness to perform their commitments. So as long as we don't blame ourselves for that. So I do agree with Denise that we are doing our job with a clearly defined nomenclature, and here we are going back to the prices, to how the pricing is done. So, for example, whether it's Nechytaylo who should be looking for these artificial increases, and all the responsibility lies with the client. The clients have no experts. They write a note to to the one who will be designing the project, and for them to be responsible, says that they will be responsible for it. And then we figure out that, yeah, the client, you are responsible for this, so please correct these. And we are not assessing the prices for tiles. Tiles could have different prices. So we, if we are monitoring artificial increases, we're monitoring the prices as indicated in the project and those prices that are indicated in the acts of the services rendered. So it was clearly intentional when it was done on so that no one could understand how it's done. So I had this case, just 500 washing sinks. There could be sinks for 30 hryvnias and for 4,000. What are we doing? We're not saying that they are. So we ask the client to provide the brand of this sink. We Google, we call Epicenter, analyze the costs, and okay, fine, you have such a washing sink. Okay, but there is a similar case when this. When some staples were the prices were went through a 100-fold increase, and for example, brushes for Ukrzaliznytsia, 15,000 hryvnias each. Toilet brushes. Yeah, there are such gilded toilet brushes. The question is whether you need this kind of brushes for public railways. So again, we have different civil society, so there are members of the public who are very engaged and active. Thank you for your skeptical view of the quality of the normative legal basis that regulates the costs and the feasibility studies, and this is an indicator that something will be happening in the field, in this field. And thank you, Yaroslava, for the 3 questions that turned into 5 broad questions, and it was a really good. As for the salaries, I suspect that in Kamiensky, nobody complains about their salaries. If you heard the numbers from Denise, the deputy mayor became the again the authorized person, so, got demoted. But then again, more money. So this is a practical question, but this is the recurring question, the motivation of people who are conducting such procurement procedures. So it all largely depends on the situation with the salaries in the country. It's hard to do a segment and a small number of important people, such as employees of NABU or other bodies where the law stipulates increased salaries. You remember the public outcry about such salaries. So if we were to inscribe this this coefficient in the law for in terms of salaries, we understand that 35,000 registered clients are all different. And so the question of salaries is reduced to the question of a specific client, and it would be great to design specific recommendations, and maybe in the next iteration of the professional standard for public procurement, 10 monitorings per year and 0 violations, 300% of the bonus. Won the case in the anti-monopoly court, then again another bonus. So these things are obvious, and in fact you can do it. So this question is regulated by the internal convictions of and beliefs of the leaders. So again, Denise sent it to NABU, and it's regulated by internal documents. So it keeps this question in focus, and it was first mentioned in the strategy of for public procurement. It lists the motivation of such persons, and you can see if you look closely that we need some ideas how to increase these salaries and how to use the motivation mechanism. So please take the mic, introduce yourself. Good afternoon, Anastasia, Odessa Oblast Council, Central Procuring Agency. You would like to ask the question to an online participants. Unfortunately, you cannot ask a question to Olga. She's not with us, so but then the question to you, but I will still be referring the question to Olga's words. Olga said that only 5% of the decisions of the Anti-Monopoly Committee was contested in the court, which leads us to think that the Anti-Monopoly Committee makes quality decisions, which leads to us making a conclusion that the clients must standardize their documentation based on the decision of the Anti-Monopoly Committee. And so how can you comment on this? What would you say? So, because we faced the situations where the decisions are made on the similar grounds, but the decisions are completely different, and the clients are struggling to understand how to what to do with the documentation, because when it expresses one position and then the grounds are different, then as the experience shows, that if we have completely different decisions in the same situation, then we see that there were in fact some differences, and maybe it's so usually it is the outcome of different content of complaints or different conditions for documentation. So we had cases where people wrote to us, you see, we are opening the decision, then the conclusions are different, but when there are two words in the documents that change the essence of the case. So I can say that we have already some practice that's been in place for a number of years. So, for example, such as the two producers, if we're talking about goods. So there are typical positions. And this is our general practice. There are, of course, standalone cases, and everything, I repeat again, depends on what is indicated in the case, and that impacts directly the decision in this or that case. I would like to add that first, according to the EU legislation, you are guaranteed the right to contest the decision of the Antimonopoly Committee in court. And if we look at the case law of the Supreme Court, there are cases where in similar cases there are different verdicts. So half-jokingly, this is, you have to pay for it. So yes, I do agree with you that we have the right to contest this decision in court. But again, when you file a complaint, it takes a long time, and it's a normal procedure in all EU countries. So this is how the mechanism works. Thank you.
So I guess Ms. Olha has spoke of the court. And this is the requirement of EU as well, that we need to contest it in the court, the AMC decision, to minimize the deadlines. We have 3-4 years of some proceedings, with contesting. So the procedure is like already forgotten. Everybody forgot everything. So the expiry date of the proceeding, it's also something that requires handling. If we take defense sector, they have very short term for appealing in courts for the defense procedures. And the similar mechanism may be to extend the terms, but this mechanism should be for administrative courts as well. In screening report, in the draft, the shorter term for procurement cases to be considered in courts, and the State Audit Service decisions, it's there. And they already started processing the amendments to administrative legislation. And the State Audit Service opinions and other codes and other documents, they already start processing this. But this is important. Please, there was a question. So we finalized these cases in all the courts from the last 3 years. When there is abuse from requesters, they contest the decisions, and in a week, the ministry will get this, and we will amend the laws respectively. So it requires a lot of time, but certain amendments will take place. But it takes time. Hello, Yulia, Dnipro City Council. I just wanted to compliment the previous speakers. I wanted to go to the website of Kyiv District Court, the first instance court for AMC decisions contesting. Currently, they don't indicate how many judges because of the martial law, but we have a case when the AMC decision about canceling the cancellation of procurement when authorized person identified one's mistakes. So there was a contesting procedure. Currently, it's a year. A year passed since we've actually appointed the judges. Yes, judges have a lot of pressure, but this is it. The minimum number of contesting cases, well, it depends on other factors. This is a problem as well. So we don't have enough people, in particular judges. It's a large problem. And last year, there was a horrible statistics, 45% of vacancies, maybe even half among judges, vacant judges positions. So this is a huge problem. Also, alignment of practices, interest to public procurement, and we have cooperation with National School of Judges. We're about to launch this online course on procurement. Judges listen to judges mostly, so they listen to other judges. And they need to unify their practices and to change approaches when it comes to AMC and Audit Service. It's the same thing as well the wages, it's hard to get one cozy room in a building where the whole building requires a major repair. It's hard to make everything perfect in procurement system related to all other state systems without paying attention to other aspects. But this is the only way. So do we have any questions or comments? Hello, everyone. So if I may, a question. Question to everyone, to all the speakers. So with all these steps and the reforms that you've mentioned, how do you see, where is the place of role of internal audit? That is actually present everywhere now in the structure. I haven't heard that from none of you, okay? In 2019, we launched the internal audit with Mariupol City Council and all the procurement procedures where there were some suspicions or doubtful things or problems mentioned by media, we checked that in the council. So they took some actions. It was a two-factor audit, so the post check and also the preliminary check. So before they published it, they had a separate unit that could provide some recommendations and compare the prices if these are too different from the market price. And it helped them to decrease the level of abuse by all the structural units. And, well, Mariupol, apart from Mariupol, we had these internal audit aspects also introduced. But it's about the specialists, their powers, and if there's political will. It's possible to launch, but it still takes time. So it's not the internal audit functionality. It's a little bit different. Internal audit does not handle inspections of internal activities. So if this was internal audit, this should be scheduled event or scheduled action. They did it. They also did it. No, internal audit should not handle these inspections, activity inspections, like business activities. They can do it with an internal audit when in the department they have an authorized person, one who is responsible for internal audit, and they have certain functions, scope of functions, what one should do. Internal audit aspect, each can identify it for specific people. We can disagree, but they also had these full-scale inspections. They had people dismissed after these inspections. And I want to add also, in Ukraine, internal audit system is not developed. Internal control, it's not developed currently. Internal audit, okay. Mostly it's about the same thing. So it's not developed. Why? Why did it happen? We need to search for solutions. Internal control system, this is something that EU wants to see in Ukraine. It's a huge way, it's a long way, and if we want it or not, but we're about to build it. We don't have other way, we just need to build this system of internal control. What is internal control system? So what this is, when people just observe externally how the procedures, the chains are performed, and one checks if these procedures are compliant, if there are problems, and gives a recommendation on how to actually eliminate this. This is what internal control is. Even the Ukraine facility requirements, they say that certain algorithm should be performed by a requester. And this algorithm is contained in those procedures that requester should formulate these chains, to have a person who will control it, regardless of what organization that is. How to improve it? One of the possible reasons why we cannot have this systemic internal control, if a sector of internal control or audit in the ministry, it's like independent, quote, quote, but everything, all its activities goes via the state secretary of the ministry, via the top official, according to the law on public service. So via the secretary, a category official, non-political. So how will one be independent if all the documents signed via other person? So this is a problem that should be handled.
Міністерствах керівник державної служби, державний секретар.
State secretary in the ministry. Declaration of internal audit. The head of unit, internal audit unit, signs with the minister. Okay, not with the state secretary. How the internal control will be independent? How will it be independent? How will one be independent from one who hires one? I asked about internal audit. It seems to me that we have another conference now. We're about to start another conference now, but difference between the audit and control, internal audit and control. Okay, this is Friday and the end of the week. We have people from the Ministry of Finance, yes, but they don't handle that. Before we reform something, let us understand if we need this difference between audit and control. How to solidify that? We have a component, but it's called internal control. Well, audit may also fall under that, but I don't think it's a legal definition, but that's a good idea. We can talk about it. Okay, if no more questions are there, I do hope we don't have anything else, reflections or questions, so I would love to have Valery Sherhin, Director of Department of Public Procurement and Competitive Policy, Ministry of Economy. Eriks, you're welcome as well. Please, let us smoothly finalize this event, and afterwards we'll have some informal conversation, okay?
Like I do it. Thank you. Забули до внутрішнього аудиту.
Okay, to internal audit, we have to accompany it with the compliance, the trendy word. People know what I'm talking about. I'll be very brief, honestly. I really like this event. First of all, because authorized bodies, we almost didn't have these in the agenda today with their speeches. Yeah, okay. Secondly, nobody was insulting authorized bodies. They just wanted them to improve our lives, make these better. Okay, if we put it serious, Thank you so much, dear organizers. Very useful. Well, we say that procurement community is, that it's already shaped like 10, 15 years ago, like basically the same people. Maybe someone used to be a requester, now in the controlling bodies, shifted slightly, but they just fluctuate in the community, but it's still there. All right. Procurement community also contains controlling bodies, and it may sound strange, but I'll support my colleagues here. In 2024, we've had so many joint discussions. Trust me, not always. These are peaceful, but not always smooth, let's say. We argue, we agree or disagree, whatever, with each other. We stay with our own opinions, but trust me, each and everybody is trying to improve requesters' lives, make it easier a little bit. And when I talk to my colleagues in department and in other bodies, well, I tell, please don't forget who is at the top position. But often this is the requester. So we need to change the focus. Requester, always requester is a traitor, he's the one to blame. It's a typical attitude, and it's an international practice. We talk to colleagues from Portugal. For a person to start working in tender committee, it's the same as we have, like the same approach. Different problems and similar with EU states. Somewhere, of course, in some cases, we're unique in some aspects. I want you to use these events for sort of a networking, first of all, to ask questions, to ask auditors some questions about your pains, maybe to complain. Antimonopoly committee. We have the whole bunch of authorized bodies here. Okay, let us have this dialogue at these conferences. Okay, let's activate it. Within the webinars or workshops, because only within the dialogue, for each party to listen and to hear the other party, only then we will generate something better, because we cannot have this one. It's a great proposal for NGO friends. Okay, let's do it like this. For the criminals to steal less money. Let's put it like that. Let us just oblige. Okay, that's what I'm telling about. Let's oblige requesters to publish the acts, publish those papers. But let's just count if this complicates the requester's life. Let's think about it. And if potentially this can give any impact. What amount of procurement do we speak about? What amount of procurement potentially can fall under the control lens, Maybe we can use other method, other risk criteria. For the audit service, it may be useful for them. So it's just, I'm okay, but the amount, the threshold amount, there is statistics, it's open. I already told you that every second procurement, starting from 30 million hryvnias in recovery, there's a corruption component within the acts, okay? We analyzed huge number of those, but every 2 weeks I'm in NABU, okay? And I want other people to sit in NABU, okay? I also support this idea because In our practice, Dnipropetrovsk region, they have so many problems. Mice eat the papers or the basement is flooded, whatever. So you can laugh, of course, but we cannot perform our functions because all these templates, these acts, these are the core documents for any inspector who is checking the procurement or in the construction area. And if Ivan or Denise comes to us, check the procurement, we come there and they have such requesters with flooded basements, flooded once in 3 months, and nobody obliges them to have the documents. You can't have a meeting because everybody's registered in Berdyansk or in Zakarpattia, and that's it. And it's impossible, basically, then to perform the duties. And so the time is wasted, and maybe law enforcement will do it, but maybe not. So we support this idea to publish these documents. In a month, we will have a joint meeting with colleagues from the State Audit Service and AMC. So, yeah.
Я обіцяв коротко.
I promise to be short, so I thank you again. Thank you to the organizers of the project for their support. And as my colleagues has stated today, it's such a pleasure to see you all here, and I think Eric's is already flooded with all the letters, all the requests. So really, that's already quite a lot. And we would like to thank you for the regional seminars that are extremely popular among our colleagues, because it's so exciting to ask questions and to talk to authorized bodies who is able to explain something, to hear you, and sometimes that's even the word of gratitude. So let's use this opportunity to talk to each other. Let's stay open, open to criticism, to advice, and I am grateful to our big clients, our businesses who share their experience with us. And we're grateful that we can do working groups with smaller businesses. Even if they're small, it doesn't mean that their issues are small. Sometimes they're much bigger. So that's why we're thinking about how to do it and to make sure that it's effective. So I'm wishing everyone a good, peaceful evening. That's all from me. Won't be telling you anything about the law.
Very true, but no doubt that we will work a lot, about the laws, and so it's certainly the theme for the coming months, coming time. I also wanted, dear friends, to thank you for coming here today. I hope that you find the conference useful, and for sure, let's continue working together. I also wanted to thank all the supporters, all our partners for making this happen, all the speakers as well, interpreters, because this is, for them, it has also been a very busy week. And since we are approaching the Friday evening, if you allow me to tell a little quick anecdote, a joke, and also to reflect on the EU accession process and timelines. So this joke is about father and daughter, but it could be also mother and son, so gender doesn't play a role here. But the main idea is that the daughter is in the teenage, the teenage, and it's Friday evening, and apparently she is going somewhere out of the house to the bar, to the cafe, or even, God forbid, to the club. And so father is coming next to the door and asking her, so when will you be back home? And the daughter is saying, when I want. And father is saying, but not a second later. So I would like with this, why I'm telling this, because I would also like to wish for Ukraine to join the EU as fast as possible and not a second later. And let's work on this together. So thank you again, and over to Sasha.